Thank you, Jay.
Sure.
I think we can jump onto employment now.
Sure.
And nowadays, you might heard a lot of cases, especially employers not paying employees dues, like 3 months, 6 months, and they are not getting proper responses when they are following up. What is the best way for them to um, get back their money? So, what do you suggest here?
So I
What
think
is the
there's going to be a
process?
common theme of
Mhm,
everything we discussed today.
mhm.
The first word I'm going to say is document,
Document.
right? The reason I say that is as an attorney, as a litigation attorney that goes to trials, the more evidence we have
Mhm,
that's in physical document, when I say physical document, email or text message, anything, as long as it's documented, not just verbal,
mhm.
right? If you can document it, that's going to come 100-fold in your favor when we go to trial, if we have to go to trial.
Perfect.
Even if we don't go to trial, if
Mhm.
I'm filing a demand notice or you've just a complaint in court, the more documentation you have, the other side's going to back down very quickly. As far as what do you do to protect, right? From an employer not paying you. First and foremost, any agreements you have with an employer, have it in writing. Because whether you file a Department of Labor claim or you file in court using an attorney, the more evidence you have, again, written, documented evidence, that's why an employment agreement comes in handy. Because if you have an employment agreement, you'll know what your wages are. You'll know whether you're an exempt or non-exempt employee, right, for overtime and all of those things. So this way, you'll have that proof. You don't have to testify. You could just show that employment agreement, and that's enough. They don't need any more evidence in that support. So have an employment agreement in place, one. Two, as soon as the first payment is missed, because if they miss one payment, likelihood they're going to miss many payments.
Mhm,
First payment is missed, follow up. Follow up immediately in writing, not verbal.
mhm,
Get it right, response in writing, what they're going to do.
mhm.
In most jurisdictions, the Department of Labor, and I'm not talking about U.S. Department of Labor, I'm talking about the statewide Department of Labor. And some states don't have it or they don't get involved in these sort of claims.
Mhm.
They have some sort of division. For example, in New Jersey, we have a wage and hour division. That division is responsible for prosecuting
Mhm.
any claims of employees that have not been paid. And what employees forget is you don't have to wait 6 months or 5 months or 3 months. You can file it immediately. Even if they miss by a day, there's penalties for the employer.
Mhm.
So you don't have to give them months and months. The longer it takes, the harder it is
The
to
harder it
collect.
is to collect.
Because if it's one paycheck, and I'm just gonna go with an employee who's making like 100,000, probably $4,000 or $5,000 paycheck, easier to get them to pay. If it piles up to 5 months, that's $50,000. It's harder to get them to pay it.
Right.
So jump on it immediately.
Understood.
And then either you follow up or file with the Department of Labor, because Department of Labor, once you file in most jurisdictions, they're just so backed up because the states don't have the funding.
Mhm.
It'll take a few months. Once you file it, if you file in January, you're probably not going to have a hearing till October or November.
October and
So
November.
it takes about 7-8 months in most jurisdictions. If you want to hire an attorney, like our firm does a lot of these claims,
Mhm.
reach out to an attorney. We'll send a demand letter out immediately. It'll curb that behavior by the employer immediately.
Understood.
So that's what I would suggest
Understood.
to kind of limit your liability.
Understood. How does the fee structure works? Because I heard from your firm that you generally don't charge upfront fees. You take the percentage from the money that you recover. Is that right? How does it work?
It depends on the type of claim it is.
Okay.
So we have 3 different type of fee structures. We have a flat fee where we just charge one fee and that covers everything. You don't have to
Okay.
worry about any more or any less.
Okay.
Then we have a contingency, which is what you were talking about, where we say, if we win this case, we'll collect a certain percentage. Whatever that amount might be, we'll get a percentage off of that. We'll agree to that percentage ahead of time, and we'll just take that. And then the last is going to be an hourly. Hourly, we just build based on the amount of work that an attorney or the staff put in on your case. So it really depends on the type of matter and what's involved. We may do different structures. And what you have to also understand, sometimes in some jurisdictions, any Department of Labor violations can also have attorney's fees. So
Understood.
the employer has to pay your attorney's fees.
Understood.
So that's why contact an attorney. You may never have to pay them because the other side might have to pay. Only time that doesn't work is if there's a settlement. If there's a settlement, the other side's not going to pay your attorney's fees.
Understood.
So contact our firm. We'll talk to you. We'll let you know what, based on your circumstances, what would be the
Understood.
fee structure.
Okay. So from employee side, we were talking until now. Are there any parameters employer can stop the payment to employee legally?
Yes and no. Very few parameters. So if the employee has borrowed money from the employer in advance, they can do that. If there's a judgment against the employee, and the court has issued a garnishment order, then the employer can withhold that money to send it to whoever that. Now, remember we talked about the insurance side. You get sued and you lose money.
Right.
If you don't have a house, you don't have a car, they can still go after your wages through a garnishment order. So if you make, let's say, $5,000 a month, the court can say you don't need the $5,000 a month because you owe these people $100,000. We're going to take $2,000 or $2,500 from your paycheck every month, and the employer will withhold it. So you don't, the money that doesn't even get to your bank, it's withheld before it even gets to you from the employer. So that's another reason that the employer can withhold. If there's any other court orders, or if there's any agreements between you and the employer ahead of time that this money can be withheld. Those are generally the reasons why an employer, and each jurisdiction again has different requirements on that, but generally nationwide that probably kind of holds true.
Understood. And when we look from employer side, most employers try to file or raise a petition in the form of non-compete. There will be a lot of non-competes, and just because employee got hired by a vendor or employee got hired by actual client, employer will always have that right to stop, right?
Yes.
So can we talk a little bit about that?
Sure. Non-compete provisions, it's a big hot topic right now. Because there was an FTC regulation earlier this year, which was supposed to go into effect from September, that said non-compete clauses are null and void in employment agreements. There has been some pushback on that. So jurisdictions are trying to grapple with how they're going to enforce that law. California, you won't be able to enforce that. Other jurisdictions, Texas, for example, they got overturned in court. So they will be able to enforce that provision. Other jurisdictions are still grappling. We actually have pending litigation in New Jersey with that. So we'll know hopefully soon how courts are going to rule one way or another on that. Before that regulation came out, generally speaking, Supreme Court ruling from the U.S. Supreme Court was that if there are any covenants or restrictions like that, they have to be limited based on the scope. So they can't just say you can't just go work anywhere. Right? They have to say if you are a very specific area, for example, I'm a lawyer, right? And I do litigation. My employer can say any litigation within a 50-mile radius of this office, you cannot compete in, right? Because they're limiting the scope and limiting the radius around, right? Geographic radius and time. They can't say forever. 1 year reasonable, depends on how much time and money they put into you as an employee and your expertise. They can maybe go to 2 years, 2.5 years, but anything more than that would be considered unreasonable and unenforceable. So if your employer says you can't ever work in this area or in this state or in this particular thing, that might be something that we can fight and get thrown out.
Understood. And can you give me some examples for non-compete? Is it only for employment? Let's say employee. You go.
Sure. Non-competes can be not just employee-employer relationship. It can also be business scenarios, right? Correct. So most commonly it's used if you're selling your business, right? I own a business. I'm selling this business to a new buyer. That new buyer might not want you to sell the business to them and then go start up a new business next door, right? So a lot of times there'll be a time limit, and a lot of times there'll be a geographic distance. So, I see this a lot. I have doctor's offices that we've done business transactions. We've done franchises. We've done restaurants. The owner sells it, then wants to go open another one 10 minutes down the road, right?
Right. Right.
That you don't want as a new buyer, you don't want it. So they put restriction on that, usually like 100-mile radius and 5 years or
Understood.
something like that.
Understood. Understood. And sometimes when employee leave a firm, especially we see in a lot of Indian consulting
Yes.
firms, when an employee leave a firm, um, along with holding a lot of dues, they also send some notices like you have to pay this much money for the trainings that we provided, for the amount that we spent on you. So how strong these cases can withstand, and does the employee really need to respond to that, or what is the best thing he have to do?
Well, so we'd have to look at their employment agreement. A
Mhm.
lot of times they have liquidated damages provision.
Mhm.
If that's there, then it potentially could be enforceable.
Okay.
What a liquidated damages provision is,
Mhm.
when you sign that
Mhm.
agreement, the employer and the employee are agreeing together,
Mhm.
saying that, hey, if either party breaches, usually it's the employee
Right.
breaching. If the
Right.
employee breaches
Mhm.
this contract, when I say breach, you're not following any of the requirements of the contract.
Right.
If you breach the contract, we don't know what the actual damages will be a year from now, 2 years from now.
Mhm.
So we're going to agree today,
Mhm.
because we can't come up with a number then, to a
Right.
number today. Usually it's 25,000 or 50,000. That's what the liquidated damages provisions are.
Right.
So you'll agree
Mhm.
and agree that it's not punitive. Punitive meaning it's not a punishment. It's
Mhm.
just that we can't agree what those damages are. So we're just going to put a number today. So both parties can be prepared for that in the future. If those provisions are there, it's
Mhm.
very difficult to fight them. I'm not saying it's impossible. We've
Mhm.
fought them and won, but it can be
It can be
difficult. The
difficult.
other
Okay.
provisions, if there are no liquidated damages provision,
Mhm.
there could be a scenario where the they can say, if you leave the employment within a year,
Mhm.
we're going to charge you penalties. But they also,
Penalties.
in the contract, they also say it's at will.
Mhm.
Well, you got to have one or the other. You can't
Right.
charge both.
Right.
So that's how we fight it, saying, hey, you're saying
Okay.
it's at will, you're saying there's a penalty for leaving, so we might be able to. And again, I say might because there's a lot of factors into it. Like if they spent a lot of time and effort on training and you didn't actually work for them at all, you just
Mhm.
received all this training and you're leaving, might not be able to.
Understood.
Versus, you did provide multiple years of billing that they made
Mhm.
money, then,
Mhm.
I think we'll be able to fight that.
Understood.